I'd like to reserve 5 minutes of rebuttal time, please. I represent Mr. Adonis Holdbrooks on this post-conviction, and not to leave Mr. McNally out, but he was the post-conviction attorney. So, anyhow, the court's obviously very well aware of the Strickland case, and of course the prongs that need to be met on post-conviction. Without conceding any of my other ineffective assistance of counsel points, I wanted to focus specifically on Mr. George Thompson, who was Mr. Holdbrooks' trial counsel, his decision to admit and use a report by Mr. Casey Bond, who was a forensic examiner of Mr. Holdbrooks' phone and the device that was being used by the alleged victim, and I use that term poignantly, and ultimately how counterproductive and detrimental and disastrous the decision was by Mr. Thompson to use this report. Mr. Holdbrooks ultimately testified at his trial, excuse me, that he believed the person on the other end using this device and using this particular account was an adult female that he had previously contacted at that account over the course of some months prior. And then when this contact was reinitiated and various lewd statements were made, various inappropriate photographs were exchanged, he believed this was some form of role play and that he was communicating with an adult. Ultimately, it turned out that he was not. The matter was reported to the police, and he was arrested and charged with various offenses that he was convicted of. In order to support this position, they engaged Mr. Bond to analyze the devices in order to demonstrate that prior to this time frame where Mr. Holdbrooks was ultimately communicating with a minor, that those devices had communicated with one another to corroborate his testimony about this, previous online exchange he had had with the mother of the alleged victim. And so that was his testimony at trial. Immediately after that, Mr. Bond's report was entered by stipulation of the parties. And the conclusions, which are contained both in the trial court's post-conviction order and they're an exhibit, the actual report is an exhibit to the post-conviction hearing. I was just going to read briefly. This is Mr. Bond's testimony in support of Mr. Holdbrooks' position. Based on the material I've reviewed in this matter, I can make the following conclusions. There is no evidence supporting Mr. Holdbrooks' claim that he interacted with any person on the tagged website, which was where Mr. Holdbrooks had said he first encountered the person using this device. There is evidence supporting the state's position consisting of messages and photographs of an explicit nature having been exchanged between Mr. Holdbrooks and the victim's device. There's evidence that FaceTime calls were placed with the victim's device 3 times in the months prior to the incident. However, these calls do not appear to have been answered by Mr. Holdbrooks. And Mr. Bond's review of the available data appears to be consistent with that of the state's examiner in this matter. And then he has the conclusion, it is my opinion that there is currently little evidence to support Mr. Holdbrooks' position that he believed he was speaking with someone he previously met on Tagged who was of legal age, and thus he believed they were role-playing during this incident. So, that was the report that was purportedly supporting his testimony. He thought he was role-playing with an adult. The trial court, or rather the post-conviction court, wrote an order, of course, that I was just quoting from in part, wherein they determined that this is not an effective assistance of counsel. And they determined primarily that because this report does make a link between the alleged victim's device and Mr. Holdbrooks' device prior to the incident, that it achieved its purpose. That the purpose of doing that was to show that Mr. Holdbrooks was being truthful, that he had communicated with this person with this account before, and therefore you got to take the good with the bad, kind of. And so the reason that it was put on was that it made this connection, and the trial court believed this was the only way that that connection could be established for the jury, other than Mr. Holdbrooks' own testimony. The only way it could be corroborated for the jury. The problem with those two conclusions is they're both wrong. First of all, the trial court hangs its hat on, like I say, that there was that this was a connection that it served its purpose. But as I say, when you come to the conclusion that there's little evidence to support Holdbrooks' position is the ultimate conclusion, the trial court goes so far as to quote, that statement and say, well, it only said there was little evidence. It didn't say there was no evidence. And the jury was instructed they could disregard this statement as it saw fit, as any other piece of evidence, which is accurate. But that really strange credulity to believe that that's somehow supportive simply because it isn't conclusively bad. It's just generally pretty bad. And then the second point, that this was the only way to get this information in front of the jury, well, that wasn't accurate at all. Mr. Bond's report, in addition to the parts that are quoted, and as I said, the entire report is an exhibit. Mr. Bond's report stated that he used, in order to prepare his analysis, information that was in the state's discovery, that the state was in possession of this information because they had the device from Mr. Holdbrooks, or at least they had the device from the alleged victim, and they also had the exchanges that implicated Mr. Holdbrooks' device. So even if they hadn't used Mr. Bond's report directly, Mr. Thompson could have used Mr. Bond's report to cross-examine the state's expert on this issue and say, well, did you find any connections between these devices before? Did you even look? And then if he had used it craftily, he would have known exactly how, I don't know how, but that's why you have experts, how these two devices would have talked to each other, and did you look at the metadata, and have you looked at these dates, and been able to make his point without having to put this report in evidence.
But the conclusion that Mr. Bond reached in that report was two things in that last paragraph. One was that there was little evidence to support Mr. Holdbrooks' position that he believed he was speaking with someone he had previously met. But the other conclusion, he believed they were role-playing during this incident. Am I reading that? I mean, that is something that Mr. Holdbrooks' attorneys wanted the jury to hear. Is that correct?
Well, my reading of that sentence, Your Honor, is that because there is no evidence to support the position that he was talking with someone of legal age, there was therefore no reason to believe the second statement. That's my reading of it, the way I took it to mean.
Okay.
I suppose that could be read a different way, but I took it to be there's no reason to believe he thought he was role-playing because there's no reason to believe that he...
But either way, the post-conviction court found this was a strategic decision by his counsel to enter this report.
It did find that, and the reason that that's wrong is because of the trial counsel's testimony at the post-conviction hearing, which the trial court or the post-conviction court elected not to deal with at all. Mr. Thompson was being questioned, and I'll question about, well, let me take a step back. Mr. Thompson had co-counsel, Mr. Newton Holliday, and his testimony was that Mr. Holliday he believed to be more adept or tech savvy, and so he wanted to have Mr. Holliday deal with the stipulation to make sure it was done properly. Mr. Holliday entered what we have seen quoted, which was unredacted. Mr. Thompson believed that what Mr. Holliday was entering had excluded that last conclusory statement, which was probably the most damaging, although I won't concede that it was not damaging even without that statement. But Mr. Thompson's testimony was, and it's my understanding that the report was redacted. I can't understand. I'm just learning that it was not. In my file, I have parts where the report was redacted, or at least the portions redacted. It should have been. I don't know why it was not, and I can't explain as to why it was not in terms of what is in the record. And then, okay. And Mr. Thompson continues, because in the record, I think it's very clear that we made it clear to the court that we expected it to be redacted. So, even though, yes, the post-conviction court determined that this was a strategic decision, Mr. Thompson says clearly, this isn't what I intended to do. This is not what we wanted to have in front of the jury. We wanted to have Mr. Bond's conclusion that there was a connection, but we didn't want to have his statement saying that there was really no support from Mr. Holdbrooks' testimony, that it wasn't corroborated by my analysis. Again, I'm not conceding that the remainder of the report is actually beneficial to Mr. Holdbrooks, even if it had gone the way Mr. Thompson wanted it to go. However, it clearly didn't go the way Mr. Thompson wanted it to go. There isn't any testimony as to, other than what I've quoted, how the ball got dropped, whether Mr. Holliday didn't communicate enough with Mr. Thompson about what should have been in, what should have been out. But I mean, this was a stipulation. The parties agreed that this was what was coming in. It wasn't a errant question or a witness that went, took a left turn and said something that they wished they hadn't. This was the report. So the fact that it was not in there correctly is squarely on Mr. Thompson, regardless of whether it happened to Mr. Holliday's witness or Mr. Holliday's responsibility. Mr. Thompson was was clearly the lead counsel, but more importantly, clearly said this was not what we wanted to do because he knew that it was damaging. And the trial court and the post-conviction court doesn't address that in its order. So I would say that this court should clearly find that this was deficient representation on Mr. Thompson's part.
The state didn't have some type of forensic expert they were trying to rebut with this report. Is that correct?
The state did have a forensic, yes.
And so did this report rebut the state's forensic expert?
Not really, no. I mean, as it says, it basically concurs with the state's position.
So their expert said there was little proof, or did it say there was no proof that he was talking to an adult?
He said that there was little proof or little evidence to support Holdbrooks' claim that he thought he was talking to an adult. Said that it is my opinion, this is Mr. Holdbrooks' defense expert, says, it is my opinion that there's currently little evidence to support Mr. Holdbrooks' position that he believed he was speaking with someone he previously met on TAG, the website.
What did the state's expert say?
The state's expert said that, you know, the alleged victim produced this device to us and was talking to Mr. Holdbrooks. I mean, let me take a step back. It's fairly uncontroverted what the exchange was. Yes, these two devices communicated with each other. The only question here is whether Mr. Holdbrooks thought he was talking to an adult or thought he was talking to a minor. So, yes, the state's expert did testify to that, but that wasn't the reason that the defense expert was introduced at all was to try to show that, hey, this wasn't the first time that Mr. Holdbrooks had communicated with this person, this device, this account. There were previous times, and that lent credence to his assertion that he thought he was talking to an adult because the account was registered to the mother of the alleged victim. It wasn't ever entirely clear to me how or why the communication started back up. If I recall from the trial, I think the communication was initiated by the minor in the name of that account, and then Mr. Holdbrooks proceeded from there and thought that they reestablished whatever exchange they had had in the past. However, yes, there was a state's expert. I think the intent was to either not necessarily rebut, but to prove, to bring out a point that the state's expert did not. But that goes to what I was just saying. I mean, there are many ways to use an expert. Mr. Thompson could have used this expert and could have said, I can't let the state ask these questions of that expert. This is extremely damaging to my client. But I can use that expert to try to come up with a way to question their expert on a level that will make sense. I mean, you know, I would certainly be the case of floundering around trying to ask the right questions of why they didn't find this and that sort of thing. And therefore, you know, using an expert just to inform your own cross-examination or inform yourself is certainly a viable or legitimate reason. But knowing that this was what the report was, and knowing that if that came in, and again, the timing I think is very important. This is immediately after Mr. Holdbrooks got up and swore to the jury that he thought he was talking to a minor, and then they present his expert who said, no, I don't really think there's a lot of evidence that that's true.
Was there anything in the record from Mr. Thompson about, other than I thought it was redacted, like any explanation of whether they had made any kind of pre-trial efforts to do that or what actually happened?
Again, what I'd quoted, I don't think that the parts of his file are in the record, but I think he's referencing that they had made arrangements to where a redacted portion was supposed to be entered as the stipulation, but that was not entered at the post-conviction.
So we don't really know what
Correct,
happened.
other than his testimony about it. That's correct, Your Honor. Addressing prejudice, I mean, again, I think I've kind of tipped my hand as to what I think the prejudice is. I mean, I'm not sure how you recover from that after, and clearly Mr. Holdbrooks didn't, he was convicted, that you know, I have this defense that I would like to use, and it could be a plausible one, particularly given the backstory. But instead, my lawyer's decision to put on this evidence from an expert undercuts everything that I just testified to. I think it definitely affected the outcome and causes a pause to whether or not the jury's verdict is on firm ground or not. So I think that there is prejudice here. I think that, you know, you select your lawyer, of course, and in some ways you're bound by the lawyer's decisions. But to answer the court's question, no, I don't think this was a tactical decision, and you know that because Mr. Thompson said that wasn't what we intended to do. But I think even if the redacted portion is in, I think it's not a tactical decision. I don't think anybody who could think that making one point that these two devices had talked to each other 3 times before, but Mr. Holdbrooks didn't actually answer the call, is worth having him say, I think the state's position is consistent, and an examination of this matter, it appears that they're right. That isn't a tactical decision. That's just a bad one. And deference only goes on to a tactical decision that's well thought out in light of the evidence. So I would say that the tactical decision is not going to save this. I think it is prejudicial because I think the timing is important. The fact that it was a stipulation that it was agreed to is important. It was not simply a mistake that was made on the stand that sometimes spins out of control. And the fact that his trial lawyer said this was a mistake, this was not how it was supposed to be. So I do think it's deficient, but I also think it caused him prejudice. So I'm into my rebuttal. Unless there's some questions right now, I'll just reserve the balance. Thank you.
General Ball?
Good afternoon, Your Honors. Ben Ball on behalf of the state. Before I get into the specifics of this issue, I'd like to briefly sort of discuss what was going on at trial here. Because what we have is the defendant, or the petitioner, has communicated with the victim who's underage, and the victim has a device, taken to be a tablet or something of that nature. She does not have a separate sort of, I guess, phone number of her own. The device is registered through her mother. And it's through this device that these conversations take place. This court will see that you know, the defendant's claim is that he's role-playing. He would have to say that because he is talking to this person, and the messages show a clear awareness that this is a minor. The role-playing claim is undermined by the images sent to him by the victim, which are clearly a child, and posing in various states of undress. But the petitioner's position was, I thought this was her mother. So trial counsel puts on this report, and yes, the report ultimately says that you could find little evidence to support his statements about it, which basically, as far as that goes, leaves him where he was. But what it also does is it tells the jury in this report that the defendant's claims are at least plausible, that this is something that could have happened, that these communications could have been appeared to have come from the victim's mother. And Your Honor, that was important. The petitioner testified, and counsel wanted the jury to understand that this was a plausible theory, even if they did not have any extrinsic proof of who he was talking to, that this was technologically possible. It may seem obvious at some level, but obviously we are all sort of, I find myself, as I get older, sympathetic to counsel here, and maybe not fully understanding the technology. I think we all sort of lock into, we're all proficient in technology when we're 20. By the time you're 40, you no longer are. But it was important here to have the jury understand that, I mean, from a defense standpoint, that while, even if they could not prove he was talking to, that what he was saying was plausible.
I mean, are you arguing that this entry of that report was not?
It was not deficient.
Not deficient.
It was not deficient because,
even though it says my review of the data is consistent with the state's examiner, and there's little evidence to support his position, the defendant's position.
well, that particular conclusion, I would argue, sort of neither helps nor hurts him. But what it does establish is the plausibility of what he says. Now, they don't have the data to demonstrate it, and part of that is because the first, he says I had initially contacted her sort of off-site. So there's not the data, but what we have is, and I think this is probably a fairly common scenario now where you have parents who are wisely unwilling to get a child a cell phone before a certain age, but as I myself have found, there are all kind of reasons that they will want to communicate through, I had a child come back from summer camp, and suddenly my wife is getting, 48 text messages that appear to be from other campers' mothers, but are in fact from campers. But it's a new enough scenario where I think that it makes sense to want the jury to understand what is happening here. And it does establish that it's plausible.
If you're saying that was tactical, did trial counsel argue that then? Did he make that part of his strategy and argument?
I mean, it was a reasonable strategy because it supported what his own client testified to.
What about his testimony that, oops, I didn't really mean for that to go in like that. I thought it was redacted.
Oh, for sure. Now, he did express some confusion about that. But at the end of the day, he got what he needed in. And as far as I would suggest that coming into this, the defendant the jury already had no evidence to support what he said. A conclusion that there was little evidence didn't harm him, and the expert opinion that the scenario he relays is sort of plausible helps him. But even had it been deficient, the petitioner simply can't show prejudice here because the story he told the jury was frankly absurd. While we could argue that the scenario he gave, as far as the initial contact and thinking it was a mother, might have been at least technologically possible. It would have shown up as the mother's name or whatever. Again, he speaks in these messages to the victim as if the victim is a child, shows an awareness as a child. And while his role-playing claim may have covered some of that, he asked for photographs. And the child sends him photographs, unclothed. No reasonable person at this point would think they were role-playing with an adult. So this single sentence in this report, even if it had been deficient for counsel to let that in, it certainly was not prejudicial because the evidence here was frankly overwhelming. What the defendant did was documented to an extent we don't normally see in these kind of cases. So for those reasons, I would, unless this court has further questions, I would ask this court to affirm the judgment of the post-conviction court.
All right, thank you. Thanks, Russ.
Just briefly, Your Honor. Again, on the narrow sort of one possible strand of useful information that came to Mr. Holdbrooks from this report showing that these two devices had been in communication at some point, there were other ways to do that, and there were much better ways to do that. Simply ask the state's examiner if that had ever happened. And as I mentioned briefly before, use the report from Mr. Bond or use Mr. Bond in talking to him to find out what do I need to ask this person so that I can sound like I know what I'm talking about when I say devices are talking to each other. I think this trial took place in 2019, 18. So yes, there might have been some legitimate concern that at that stage people didn't understand that accounts could be on different devices and they can talk to each other. And yes, it is actually plausible. You may not know who you're talking to just because they're using Ben Russ's account doesn't mean it's Ben Russ, just because it goes to a tablet or it goes to a phone. So there could have been usefulness there. I mean, a necessity to show that that's probably not in 2026. I'm not sure if people are as confused by that idea. But be that as it may, he could have asked the state's expert all of those questions, used his expert for that purpose, and gotten a much cleaner but effective way of proving this connection. Or on the other hand, that the state's examiner didn't bother to do this. And then that could have its benefits as well. So on that narrow issue, I think the only possible thing that was beneficial to him, there's still better ways that he could have done this. So,
But we're talking about, the evidence we're talking about is evidence about what Mr. Holdbrooks believed.
correct, Your Honor.
Not evidence about the age of the person he was communicating with.
Well, I think it's part and parcel of the same. I mean, his testimony was that he thought he was role-playing, and that all of the communications, even down to the pictures, were part of the role play, and that was ultimately what happened is he showed up at a location where he thought he was meeting the person he was communicating with, and then he was arrested because at least several of the last exchanges were with law enforcement and not with either the alleged victim or her mother. And so they had him set up, and that's the basis of the charge. It actually wasn't the exchange of the pictures that was the basis of the charge. But yes, this goes to corroborate his assertion from his trial testimony that he thought he was role-playing with someone who was above age because he had done so in the past with someone who had the same account. And they could have demonstrated that that had happened. They had communicated in the past in a lot better ways than using this report. So, thank you.
All right, thank you, Bruce. Ready to go? Or you
I'm good, whatever you want to do.
want a break? All right, we'll take just a short recess.
Okay.